Happy Saturday. I am going to give you an update today on a couple of things in particular. First thing is for people who have been receiving RFEs, H-1B applications on their STEM OPT applications, who have had some amount of involvement with a company that has been investigated by ICE and found to have some non-compliant practices. And specifically, for those of you who know, I'm talking about Wireclass, Andwill, Integra, and a couple of other companies who have been missing. And what we are finding, and what has been the case for, I think, several months now, is that these companies, any person who has been involved in this company in any capacity is starting to see some kind of pushback from the USCIS or, consulates, even at the border while entering the US. And what we are finding in particular is that many people who have had no problems up until now, and their involvement with this company has been well into the past, are now seeing RFEs issued as they are applying for new types of applications. I wanted to make this video particularly because H-1B season is coming up. And I know that many people who have had some form of involvement with one of these companies are going to be participating in this new H-1B season. And so I wanted to touch base and kind of give you some rays of hope and some feedback as to what you can do to protect yourself. So again, about people who have had involvement in a company where they were not paid a salary, so it was an unpaid employment, under their OPT status. And this is usually when people are allowed to have an unpaid internship and unpaid employment of some sort. But the problem is that many times when they do take on this unpaid internship, the company does not really fulfill the obligation of providing the requisite training, the requisite work, or maybe the company tries and cannot find the requisite, project for that person. And so then, instead of having a productive time working in this company and getting experience, getting training, the employee or the student trainee is stuck basically wasting time and applying for jobs elsewhere. And the problem that has come to light is that some of these companies have been investigated and have been found to be charging people a certain amount of money, giving them offer letters, and then not fulfilling the roles, not providing them with the adequate work that was promised in the offer letter. And luckily, we are seeing some positive results from responding to RFEs for continuation of status. That is how it's showing up in many cases. People are receiving RFEs saying, prove that you didn't fall out of status, prove your continuation of status. And they're not being always specifically mentioned, or these companies are not always specifically mentioned. But what we find is that really that's what that RFE is about. That RFE, if you have been involved in one of these companies and you can, know yourself, that's what that RFE is really about. It's not about just a generic continuation of status. And so providing that offer letter that was provided to you by that questionable company is really not going to do you much favors. So that's basically what I wanted to address. And then the other thing is that I wanted to, I wanted to also talk to people about some strategies that can be taken into account while you pursue these options. So for an example, one strategy is that you can look at this RFE as a little differently. First of all, if you are somebody who has been involved with one of these questionable companies, then in that case, you have a decent shot okay? And that's what we are finding. You have a decent shot at being able to overcome this RFE. Why? Because you as the employee or as a trainee may not bear the complete responsibility for the actions of that company, for what training was provided or not provided, for what employment or projects were provided or not provided. And so we are finding that, you know, where people have been involved with these companies for a shorter amount of time, specifically less than 6 months, there's a greater likelihood of success. Now, keep in mind, everything that I'm talking about in this video here, please do not take it as legal advice in specific. I am giving you some general information. So your case might be different, and you really do need to consult with us or another attorney to really get the facts of your case looked at, to know what your chances of success in this situation are. For people who have been involved with one of these companies for longer than 6 months, it is a very big case-by-case determination, and the chances are slightly longer time, but that does not mean that the chances are completely eliminated. So I want to just point that out to you. The second thing I want to tell you are some strategies or some things you can do today to help your situation if in the future you do receive one of these RFEs. So one thing you can do is save any form of communication you have had with members of this company. That includes WhatsApp messages, it includes emails, it includes any records of phone calls that you might have had, anything you received, any documents you received from them. Even if you think it's not relevant, save it, okay? The second thing you can do is save any kind of proof of any trainings, even if they were not through that company directly, even if you independently sought them during the time that you were with this company. The third thing, if you were applying for other jobs, you want to save proof of your application efforts. So that includes, you know, acknowledgements of your application, emails, anything, any communication you have received from rejection letters, and any communication you've received from jobs you've applied to while you were employed with that company. Here's one thing that I know for sure: you should never eliminate referring to that company or mentioning that company when you talk about your employment history, because you've received an I-20, and because you were involved with this company for a certain amount of time. If you fail to mention it, in response to the RFE, that's a sure sign of misrepresentation. And if you also fail to acknowledge some of the difficulties that have happened with this company, you just provide maybe the offer letter, that is also not good enough. So please keep in mind, you want to provide adequate information, but it is far, far better to work with an attorney who can synthesize all of this information in a way that supports the legal argument for your case. Okay. I also wanted to talk about H-1B this year because it's coming up. It's right around the corner. The lottery period starts March 9th and goes through March 25th. And then the application period starts April 1st. There has been some confusion about what this season will look like, and there have been, proposed changes. But I'm here to tell you that those changes will not be in effect for this particular lottery season. So this year's lottery, this year's H-1B should look almost identical to last year's, which means first a lottery period for anyone who has not previously been counted in the lottery. And then you can, if you're selected in the lottery, you can go ahead and submit your application, or rather your employer can go ahead and submit your application. So you really want to make sure that, a couple of things that we learned from last year: sometimes people had job losses after being selected in the lottery through one employer. Well, unfortunately, if you were not selected in the lottery through a particular employer, you cannot change the employer and apply through a different employer. So you have to apply through the employer who filed for your lottery application. Can you apply through more than one employer? Yes, but you have to be careful because the same employer cannot apply for you multiple times. Now, sometimes this happens accidentally. So how this sometimes have happened, or last year how it has happened in a few cases, is that as the employer was submitting an application for their employees' lottery, they encountered a blank screen and they thought it didn't go through. And so they kind of went back and resubmitted it. Very big mistake, because that was considered to be a double submission, and that person was eliminated from consideration in the lottery. So if you are, guiding your employer, or, please make sure to let your employers know once they submit it, even if it shows a blank screen or if there's a glitch in the system, to go ahead and check their account to see if it has been submitted before resubmitting the application for the lottery, because that will automatically eliminate their employee from consideration. Make sure that you're identifying a particular person in the employer's, company who will be responsible and responsive during this period of time, because it's a very technical submission, and a lot of times we have to guide, particularly smaller employers, we have to guide them through the whole lottery submission process so they know how it's done, and they do it all the way. And so we need to be in communication with these employers regularly, and there should be one particular person who is available during this period of time between March 9th and 25th to actually, make sure that they're doing what needs to be done in a timely fashion. So if you have not, or if your employer does not have a legal team already, and you have not secured an attorney, or your employer has not secured an attorney for this H-1B process, it is time. It is time. Please do not wait till the last minute, because attorneys will start becoming booked up. And, we still have availability now, but we may not have availability later. And I can tell you a little bit about the kinds of H-1Bs that we process. We process H-1Bs mostly for smaller employers who have 1 to 2 H-1B applications at a time. We do not currently have, the practice style, I should say, for mass producing H-1Bs. So we definitely custom create each application, and we're very well equipped to handhold the employer, especially if they don't have much experience with the H-1B, to help guide them through this process, because it is a complex process if you've never been through it before. So if you are looking for your employer to file this application, you would want to connect them with our office, feel free to call us at the number here, 312-854-7065. We'd be happy to talk to you, happy to talk to your employer to see if we can work together. Also, if you are one of the people who have been involved in one of those companies that I mentioned earlier, Andwill, Wireclass, etc., and you wish for some kind of assistance, or you want to just consult to know your options, also please call us at the office at the same number. All right? And okay, well, I hope everyone has a wonderful weekend. If you're in Texas, I hope you're safe. I feel terrible about the people who live there, and some of the things that we are hearing in the news. And okay, well, take care.